Every Canadian privacy law gives individuals a right of access to their own information. If you think about it, it's a key way that an individual can hold an organization accountable for the information they collect and how they use it. This episode will give a rundown of what that looks like in the federal private sector privacy law, how organizations need to comply, and what the exceptions are to this broad right of access. Hi, my name is David Fraser. I'm a privacy, internet, and technology lawyer with the Canadian law firm McGuinness Cooper. I also teach internet and media law at the Schulich School of Law at Dalhousie University. In this channel, I try to provide educational and informative content about Canadian privacy and technology law. You should check out the full disclaimer below, but you should know that I'm about to give you a very high-level overview of a pretty complicated and nuanced subject. Outside of Canada, the right that an individual has to access their own personal information held by an organization is usually called a data subject access right. But whatever you call it, this access right has a very long history. The grandparent of most modern privacy laws in Canada, in Europe, and around the world are the OECD guidelines for the protection of privacy and transborder flows of personal data, which were made effective in 1980. It's not law or a formal international treaty, but became the foundation upon which most modern privacy laws were built. The OECD guidelines include something called the Individual Participation Principle, which says that an individual should be able to ask a data controller whether or not they have data related to the individual. If the organization does have any such data, it should be provided to them at a reasonable charge, if any, and within a reasonable time. If the request was denied, though the guidelines don't set out reasons to permit denial, the individual should be given reasons for the denial and to have a way to challenge that denial. If the individual doesn't agree that the information is accurate, they should be able to have the data erased, fixed, or amended. Every single Canadian privacy law incorporates this principle in slightly varying ways, from the Federal Privacy Act to the provincial public sector access and privacy laws, through to the Personal Information Protection and Electronic Documents Act, and of course the substantially similar laws of BC, Alberta, and Quebec. In this discussion, I'll focus on the Personal Information Protection and Electronic Documents Act, or PIPEDA. In substance, I don't think there are any material differences proposed in the new Consumer Privacy Protection Act. The wording in the Canadian Standards Association Model Code for the Protection of Personal Information tracks pretty closely to the OECD guidelines. You'll recall that the Personal Information Protection and Electronic Documents Act, which is Canada's federal private sector privacy law and which came into force in 2001, includes the CSA Model Code as an appendix. This sets out the general rules, and the body of the statute sets out some of the details and some of the exceptions. The individual access right is set out in Principle 9. So here's the general rule. Upon request, an individual shall be informed of the existence, use, and disclosure of his or her personal information and shall be given access to that information. An individual shall be able to challenge the accuracy and completeness of the information and have it amended as appropriate. The devil is, of course, always in the details, but that's the general rule. There are a number of sub-principles. When you're reading them, you need to remember that these are from the CSA Model Code. PIPEDA says that where the word may is used, this is optional. Where the word must or shall is used, it's an obligation. And there are a number of key elements in the body of the statute which we'll get to. In Sub-Principle 9.1, it says that an organization has to tell an individual on request if they have any information about them. They should tell them where the information came from, and they should give the individual access to that information. Interestingly, it says the organization has to be able to tell the individual how they have used that personal information and what third parties it may have been disclosed to. Sub-Principle 9.2 says the organization may require, and I think they really should require, that the person provide information like proof of identity so that the organization can fulfill its requirements. It would be deeply problematic if they were to disclose someone else's information. And this additional information can only be used for this purpose. In Sub-Principle 9.3, it says that the organization should attempt to be as specific as possible about third parties to whom the information may have been disclosed. If that's not possible, they need to provide a list of all the third parties it may have been disclosed to. Sub-Principle 9.4 says that an organization shall respond to an individual's request within a reasonable time and at minimal or no cost to the individual. Now, in the body of the statute, it says 30 days is the statutory time limit. It then says that the information needs to be generally understandable, so if abbreviations or industry jargon is used, it has to be explained. The next sub-principle gives an individual the right to have their information corrected or amended. This is tied to the accuracy principle, and the organization has to transmit the corrected information to the third parties who may have received the inaccurate information or incomplete information. It then says in the next sub-principle that when a challenge is not resolved to the satisfaction of the individual, the substance of the unresolved challenge shall be recorded by the organization. When appropriate, the existence of the unresolved challenge shall be transmitted to third parties having access to the personal information in question. Now we've gone through the general principles, you have to flip back up in the statute to see how these are altered or clarified. All of this is in sections 8 and 9. So requests, in order to be official, have to be made in writing, and the organization has to assist the individual in making any requests. The organization has to respond diligently, but no later than 30 days after receipt of the request. The organization can extend the time limit for another 30 days if meeting the original deadline would unreasonably interfere with their activities, or if they have to undertake consultations with third parties to process the request. They can also extend it if the information has to be converted to another format like Braille or from audio to transcript. If the organization needs an extension, they have to give written notice and reasons, along with advising the individual that they can complain to the Privacy Commissioner. If they don't meet these statutory deadlines, then they are deemed to have refused the request. Section 8 sub 6 says an organization can charge for access, but it has to be reasonable, and the organization has to advise the individual of the cost. Any refusal of access has to be in writing and has to give reasons. And here's a very important provision. An organization must retain all the requested information so that the individual can exhaust any recourse they may have. This should be treated by the organization like a litigation hold, since violating this is one of the very few offenses under the statute. Then, Section 9 sub 1 says an organization is prohibited from providing an individual with access to their information if doing so would disclose a third-party individual's personal information. But if they can sever the third-party information, they have to do so and provide the balance to the person making the request. This limitation, of course, doesn't apply if the third party consents, or strangely, if the individual needs the information because an individual's life, health, or security is threatened. Then, Section 9 sub 3 sets out a number of circumstances where an organization has discretion to refuse to disclose certain personal information. The first category is information that is subject to legal privilege. The second is where providing the personal information would reveal confidential commercial information. The third is where the disclosure could reasonably be expected to threaten the life or security of another individual. Next is if the information was collected under paragraph 7.1b, which is for investigations into a breach of an agreement or a contravention of the laws of Canada or a province. Fifth is where the information was generated in the course of a formal dispute resolution process. Finally is where the information was created for the purpose of making a disclosure under the Public Servants Disclosure Protection Act, or in the course of an investigation under that act. I've never seen that one come up in my years of practice. The organization has to sever confidential or threat-creating information and provide the balance if they can do so. Interestingly, the statute says that these exceptions do not apply if the individual needs the information because an individual's life, health, or security is threatened. On to Section 9, which also contains a whack of rules that have to be followed if an individual asks the organization for any information about whether their personal information has been disclosed to law enforcement or to the government under certain provisions of Section 7 sub 3. I won't get into too many of the details, but an organization facing such a request should immediately seek experienced legal advice. In essence, the personal information cannot be disclosed to the individual without the permission of the law enforcement or government agency that acquired the information. Frankly, I think this is BS. The police can get non-disclosure orders with their warrants and production orders. If they fail to do so, they snooze, they lose. Also, it could actually prevent a suspect or a person charged with a crime from obtaining exculpatory evidence unless the cops give their okay. Now, regardless of whether I think it's BS, it is the law. One thing that I often point out to clients is that if you do not commonly receive individual access requests, these often are a prelude to litigation. This gives individuals a right to see information that could be the foundation of a lawsuit or an employment-related claim. And the fact that it could be used for pre-litigation discovery or may even happen during an ongoing dispute doesn't change the access right as it is freestanding. And finally, you'll find that the rights, processes, and rules are generally the same under all of Canada's public and private sector privacy laws. I hope this has been interesting and useful. I try to put out a new video each week or so if you're interested in this sort of stuff, please click the like and subscribe buttons. Also, leave a comment if you have any questions or if you have any suggestions for other topics to cover. And of course, feel free to share this with anyone who you think may be interested in hearing about developments in Canadian tech and privacy law. Thanks so much for tuning in.